I think we can start with the chairperson of
the Criminal Procedure Code Amendment Bill, National Assembly Bill number 11 of 2026, and number 2, the Penal Code Amendment Bill, National Assembly.
Honorable Speaker, I beg to leave.
Retirees are lawfully entitled to receive their pension in a timely manner so as to meet their basic needs and live with dignity. Regrettably, Honorable Speaker, many pensioners continue to face prolonged delays in the processing and payment of their benefits, thereby subjecting them to financial hardship during their retirement years. Honorable Speaker, these delays have caused unnecessary suffering, particularly for pensioners who rely solely on their monthly pension to meet daily needs, to access medical care, and to support their families. The situation is even more dire, Madam Speaker, for elderly pensioners, some of whom endure extended waiting periods, while others tragically claims as at June 2026, and the number of pensioners whose retirement benefits remain unpaid across the country. Number 2, reforms in place to strengthen pension administration system, to reduce bureaucratic bottlenecks and guarantee that pensioners.
Honorable Speaker, I beg to weigh in this very, very important statement raised by my colleague, Honorable Stephen Mugaka. Honorable Madam Speaker, the issue of pensioners has been canvassed that will ensure that pensioners receive what is due to them immediately after retirement. Honorable Madam Speaker. Honorable Madam Speaker, I support this. I support this Speaker. I support this. I support this statement. And I say this time, Honorable Madam Speaker, let's get an answer that will satisfy our pensioners countrywide. Thank you, Honorable Madam Speaker.
Okay, Chairperson, for somebody to speak for, to give an undertaking on behalf of the Finance Committee. Yes, President.
Thank you, Madam Speaker. I want to thank Honorable Makaka for raising that issue. In fact, I was from chairing a committee which we discussed a statement by Honorable Kibakendi.
Thank you. Thank you. Then we have a statement that's being responded to. I'm told by the Transport and Infrastructure Committee. I think Honorable Dawood, were you the one to give the response on behalf of the committee? Yes, proceed.
Thank you. Thank you, Madam Speaker. This is the response on behalf of the Chairman Transport Committee. It's Honorable Speaker, Honorable Member for Madoia, Honorable Dr. Edwin Mugo requested a statement
from the Chairperson of the Departmental Committee on Transport and Infrastructure regarding the deteriorating state of Thika Superhighway.
Honorable Speaker, in the statement, Honorable Dr. Mugo sought to establish so as to enhance road safety, and 3, the timelines within which the government intends to complete the necessary repairs and rehabilitation works to ensure it is in a motorable condition. Honorable Speaker, the committee received a response from the Ministry of Roads and Transport through the Clerk of the National Assembly, which I now wish to make. Honorable Speaker, regarding the maintenance and rehabilitation plans, the Ministry submitted that Ngara Canal comprises the Nairobi-Thika Superhighway S1 and the Thika Canal section of the A2 road. The maintenance interventions undertaken on the sections include surface dressing on the Nairobi-Thika main carriageway in 2019, localized repairs and pothole patching along the service lanes in 2025,
and rehabilitation on selected sections along the non-motorized transport facilities walkways in 2025. Number 2, Madam Speaker, the Ministry further submitted that there are ongoing performance-based maintenance contracts on the Nairobi-Ruiru section.
The major scope includes construction of bus bays at Roysambu and Githurai, aimed at improving traffic operations and safety along the sections, pothole patching at failed sections, installation of road signs, road marking along the constructed bus bays, and performance-based maintenance on the carriageway, road reserve, and structures to the required service level. Madam Speaker, number 3, on the Ruiru Thika section, the ministry submitted that the scope includes construction of climbing lane along the Blue Post section at Thika, construction of bus bays along Waithaiti section, pothole patching at failed sections, provision of road marking, and performance-based maintenance of the carriageway, road reserves, and structures to the required service level. Number 4, on the Thika Canal section, the ministry submitted that the section of the A2 road was recarpeted in 2022 due to the budgetary constraints sealing. The ministry further submitted that the road is currently under a performance-based maintenance contract whose major scope includes drainage works comprising provision of access culverts 900 millimeter and drain excavation, localized base repairs with hand-picked stones, surface tracing with 6/10 chippings, and 80/100 penetration grade bitumen. Sections, provision of road markings and other specified road furniture, and performance-based maintenance of the carriageway, road reserve, and structures to the required service level. Number 6, due to the budgetary and contractual constraints, the ministry submitted that the current contract quantities are insufficient to accommodate AC overlay on the severely reveled sections. It has thus been considered necessary to forego the surface dressing and utilize along the Thika Canal section due to the inferior pavement structure. In view of this, the road section requires additional funding, procurement processes, and fulfillment of statutory requirements. Number 8, Madam Speaker, regarding the delay in repairing potholes and other damaged sections, the ministry submitted that since opening of the Thika Superhighway to traffic in the year 2012, the major maintenance interventions undertaken on the highway include inherent limitations in the original pavement design. The non-motorized transport facilities were constructed with a 35 millimeter asphalt concrete wearing course, while many sections experience poor drainage that has accelerated pavement deterioration. Similarly, the service roads are constructed with less robust pavement structure than the main carriageway, making them more susceptible to premature failing under the increasing traffic loads. Number 10, the ministry stated that KENA carries out regular road condition assessments through ARICS, that is Annual Roads Inventory and Condition Survey, DRMIMS, that is Dynamic Response Intelligence Monitoring System, and routine inspections to identify and prioritize critical interventions. However, the interventions undertaken over the years envisage only holding maintenance. Comprehensive rehabilitation and reconstruction of the affected sections will be undertaken subject to availability of funds. Due to budgetary constraints, delays have been experienced in the undertaking the required treatments, including base repairs, reconstruction of the failed sections, and drainage improvement works. Number 11, regarding the timelines for completion, the ministry submitted that the holding maintenance works under the ongoing performance-based contracts are continuous and will be undertaken throughout the contract period to ensure the road remains safe and motorable. In the year 2025-2026, the allocation for maintenance was 1,632,612.41, while in the year 2026-2027, the amount for maintenance is 1,649,541,541 319. 12, the second last. On the Nairobi-Ruiru section, the ministry submitted that the contract commenced on 9 June 2025 and is a 24-month contract with a scheduled completion date of 8 June 2027. On the Ruiru-Thika section, the contract commenced on 9 June 2025 and is a 24-month contract with scheduled completion date of 8 of June 2027. On the Thika Canal section, the contract commenced on 24th of November 2025 and is a 24-month contract with a scheduled completion date of 23rd of November 2027. Lastly, the ministry further submitted that the comprehensive rehabilitation and reconstruction of the Thika Canal section will be undertaken subject to the availability of funding, completion of the requisite procurement processes, and fulfillment of statutory requirements. Thank you, Honorable Speaker. I submit on behalf of the Chair of the Transport Committee, and Madam Speaker, I have already given the Member of Parliament for Modoia a written response. Thank you, Madam Speaker.
Is a member who requested this?
Honorable Speaker, maybe there are some responses, but there are some issues which maybe they have not been adequately responded to. And one of them that has been introduced in the response is the construction of bus bays in Roysabu, Githurai, and Wetavia, because this bus base will be an important factor, in decongesting the road and also managing the issues of road accidents and so forth. They have not given us the timelines on when these bus roads will commence and when they are going to be completed. Number two, Honorable Speaker, the response has introduced the issues of construction of a climbing lane at the Blue Post section, but they have just mentioned it. They have not told us maybe when is it starting and maybe when is it coming to an end. And finally, Madam Speaker, the statement, the issue, the common factor here is the issue of funding, additional funding. And probably now that we even have the National Infrastructure Fund, probably the response has not told us when these funds will be availed so that this road can be in a better condition. And also, Madam Speaker, we can also look at the low-hanging fruits like the street lighting in this road. The street lighting for the road is in very poor condition. If the
Speaker, with your indulgence, riding on that response from the Chair Committee on Transport to the Honourable Member for Madhioya, although the member for Imenti North referred to Madhioya as Modhioya, it is Madhioya constituency. Honorable Speaker, I know many members may not have been paying attention to your communication, which you communicated on the rejection of a bill that was passed by this House in October of 2025. And we are headed to October of 2026. And you indicated that immediately this House passed that bill, the Speaker's office did relay a message to the Senate on the passage of the Roads Amendment, the RMLF bill. Members will remember this is a bill that was apportioning money from the Road Maintenance Levy Fund to both KERA under the national government and part of this money going to our counties. And if members did not pay attention, the Senate has done the unthinkable. They rejected the bill in second reading. Not even with amendments, rejected the bill in roads in your counties and in our neighborhoods, Honorable Speaker. Some of the issues you've had the Honorable Member for Madhioya raising are issues together with other senators in the other house. Honorable Speaker, part of what we intended to do with this bill is to ensure that there is no duplication in allocation of funds to roads at the local level, Honorable Speaker. Because what has been happening in our counties, because the public are not aware which road is classified as a county government road and which one is classified as a national government road. Governors have been taking money from RMLF, duplicating the same roads that they are allocating their county revenue. What is it called? This Kamkat bill. The Equalization Fund appropriation bill is rejecting a bill in totality. You cannot reject a bill in totality. There must be one or two clauses at least, even the title that you agree with. But you know, it's a rejection in jest, Honorable Speaker, and to spite this House. But I want to tell senators, you are not spiting this House. You are spiting the same people you will be going to vote for you next year. They will be asking you, what have you done to make sure that money, RMLF money, gets to counties to fix roads in our neighborhoods that are not being fixed because money is not going there, Honorable Speaker. Therefore, Honorable Speaker, as I congratulate the committee on transport for the response they have done, I wanted to write on that, to remind the House that we have done our bit and we will continue to do our bit as pertains to the allocation of RMLF money, but we must, Honorable Speaker, 10 years after devolution, the advent of devolution, there is no change on the ground because of theft at the county level, Honorable Speaker. I miss the days, Honorable Speaker, before these people went to court, when we would appropriate that money here and it would be procured at the national government level. And that is the right thing to do because there is even better equity at the national level than at the county level. Therefore, let me ask that the members will be appointed to the mediation committee to ensure that we buttress the position that we took, that what
goes to Kera must remain with Kera. What goes to the counties must go to roads that will not again be duplicated at the county level budgets, because that is what governors have been doing with a clear attitude in the Senate on this RMLF bill. Thank you, Honorable Speaker.
Honorable Member for Tiati.
Speaker. Honorable Speaker, thank you very much for this opportunity. Madam Speaker, I want to agree with the Leader of Majority that one of the biggest
mistakes of our Constitution was the creation of the Senate. It is a terrible mistake of history that we created that house called the Senate.
But Madam Speaker, while we have that house existing, we'll have to deal with it. And I urge the Leader of Majority to live by his word and appoint a very strong mediation committee so we look into the issues of the RMLF. And I want to confirm, Honorable Speaker, that indeed there is a lot of duplication happening in the counties. Duplication through RMLF, duplication through the Equalization Fund. And one of the biggest problems we have is that Equalization Fund. And I want to tell you, Leader of Majority, you are lucky that you withdrew that bill, the appropriation bill for equalization. We would have thrown it out until we solve the issue of the procurement function. It is one of the biggest mistakes that was done by the Treasury to bring regulations, Madam Speaker, that allocates the power of procurement to the county governments. And that's where the problem comes in. That's where they come and do their duplication. An outright plunder of public resources. So, Madam Speaker, I just want to say that I want to urge honorable members, when the minister comes, I hope he will come tomorrow, let us all come in numbers, and while I do not want to anticipate debate, but let us all come in numbers and for once and for all, deal with the matter of the Equalization Fund so that the people and the counties and the communities that are supposed to benefit from this fund can be able to benefit as per the Constitution and as per the vision of the makers of our constitution. Thank you very much, Honorable Speaker.
Member for Buri.
Thank you, Madam Speaker. Just like the majority leader said, I think it has never happened in the two parliaments we have been tolerant than this other one. When we think we are moving in the right direction and the country is trying to manage the resources properly, the others who are not recognizing the positiveness of the things that the government is doing. Madam Speaker, one of the greatest problems that we have in the counties is the capacity to manage the resources that has been appropriated to them. Road sector being one of them. Madam Speaker, we have a problem with the way the county is managing donor-funded. The Senate need to feel it. They really need to come out clean and tell Kenyans what their respective counties have done with the money that has been appropriated to them, and specifically the roads. I will challenge my senator to tell us what money has been put to the roads and what project of roads have been done in the 9 constituencies of Meru County. Mr. Speaker, it defeats the logic. It is undermining the intellect of these members, the 290 members, who have managed their constituency with the 22% and 10%. And significant things can be seen in the road sector. Madam Speaker, when everybody is saying, let's give service to our citizens, the Senate is refusing in totality a bill which has a lot of positiveness in it. Therefore, Madam Speaker, we are left wondering, are we serving the same citizens? What is the Senate representing? That you can reject the bill in totality, and the benefit of this is to the citizens they purport to serve. If there is anybody killing the revolution, is that House called the Senate. And I think time has come for us to call it out. I thank you, Madam Speaker.
Thank you. I think we can go to the next order. Okay, member for, you may proceed. Member for Mogotio. Not Mogotio, sorry. May proceed, Honorable Makilap. Give him the mic.
Thank you, Madam Speaker. Writing on the response from the Honorable Dahoud on behalf of the road sector constituencies, as you may be knowing, Madam Speaker, that if you go today to every constituency in Kenya, the roads that you see being worked on are the little money that the constituencies receive as 22% of RMLF. You will wonder what happens with the budget of the county governments on the road sector. What happens to the money that are allocated to the county governments? And if senators are able to reject it without even the title of the bill, without reading, Madam Speaker, the question that Kenyans are asking is, do we really need Senate? Do Kenyans require Senate? Do Kenyans require Senate? Kenyans do not require Senate. I think Parliament and National Assembly can transact business of this country without the Senate, because the Senate have reduced themselves into oversight in what MCAs are supposed to be doing in the counties. Our functions in the 4th schedule. The work Senate are doing is what
MCAs of Kenya must be oversighting their county governments. Why do we have a situation where
Senate summon Minister for Energy, Minister for Education, Minister for Security? What business do they have? That is function of national government. Let them read the 4th schedule. Madam Speaker, this matter is by the members of this House. That's what the law says.
So we, in fact, going forward, if there is money to be allocated for equalization fund, Madam Speaker, the project, money to be allocated for equalization fund, Madam Speaker, the projects must be itemized in our budget, so that when we pass the equalization fund, we pass with projects itemized and costed, Madam Speaker, so that we have real-time projects taking place in our counties. It is a lacuna. In fact, the charges did not read the constitution properly. What Parliament appropriates must oversight it. What the MCS will appropriate in the county governments, they call an oversight. Madam Speaker, we need to review this and call the Senate to order so that programs of this country, development in this country, are not duplicated. Programs in this country can be able to be felt by the citizens who elected this House of Parliament. Madam Speaker, this is a serious matter that going forward, and even the committee that will be appointed for mediation, majority leader, appoint people who will not change their minds or could be convinced otherwise. People who have the interest of this country at heart.
Madam Speaker, I think the greatest mistake that the 2010 Constitution made without knowing is the establishment of Senate. I think that was the greatest mistake, and time has come when we are coming head-on with the truth. If, Madam Speaker, what they can do to reject in totality what goes to their voters, what goes to them, and they are the same people who claim that there are no roads, no lights and lighting, has amended that section called Senate. Carry all those functions to the National Assembly. Because this House makes all laws. If, Madam Speaker, Mr. Speaker, sorry, if this House looks in totality the total amendment of the Constitution, whatever method, we must remove Senate for this country to be safe. I think Senate has taken us so far badly that rejection in itself, and it's good, Mr. Speaker, that they have rejected the entire thing.
Let's have the Honorable, who had this statement? Mutunga, or let's hear Mutunga first. Proceed, Mutunga, Honorable.
Thank you very much, Honorable Speaker. Honorable Speaker, I've listened very carefully to what the members are saying, expressing their discontent with the action of the Senate. Honorable Speaker, if you look closely at what Senate does, I do not pick which provision in the Constitution they follow in much of the work that they do. Senate oversights ministers or CSs, cabinet secretaries. Instead of oversighting the governors, they keep calling the cabinet secretaries to their offices. They keep calling the PSs and ends of institutions. I do not know where this provision is, Honorable Speaker. On there is a 22% and a 10%, which comes from the levy. Senate has been eyeing this to pass it, either not done, unless where MCAs have stood there, either not done, unless where MCAs have stood their guard and forced the governor in place to give them money to do the roads. And they put such money in the budgets. It has not been happening. Honorable Speaker, they used to modernize towns, put cabrals on towns. We have seeing very little happening nowadays. We only see senators trying to fundraise for the governors. Honorable Speaker, I've been involved in about 3 mediations. And in all the 3 mediations, there is one common factor that has been under discussion.
And the common factor is how much more money do we raise for the governors. That is the relationship between Senate and the county government. Is that preserving and promoting devolution? Is that what Senate was created for? Is Senate a house to fundraise for the nations? Almost fail because we are not able to agree on proportions. Even the monies, or rather the resources that target specific commodity and specific commodity roads, They also want such roads to be managed by the governors. And we know this money is not used to do the roads, it is used to travel the world. It is used to do all other odd things. So, Honorable Speaker, I want to join my colleagues in saying that Senate is not necessary in this country. We do not need it.
Very well, Honorable Dawood, close this matter.
Thank you, Mr. Speaker. Mr. Speaker, Honorable Dr. Edwin has talked about the construction of the bus stops at Roysambu, Githurai, and Waidete. And the timelines, I promise to get back as soon as we are back from a reply. Regarding street lighting, as my colleagues have alluded, that is under the county government, but we will still ask Kenna about it and the footbridge. Mr. Speaker, I want to just say one thing about what the majority has talked about, the RMLF, and going down, DE and unclassified are under the county government, Mr. Speaker. And when we do the roads, under 22% and 10%, we do even the county roads as to the county assemblies. And we then have a department in Parliament, a committee of devolution in Parliament, because when I was in the CIOC, that's what was happening, Mr. Speaker, but that bill did not go far because it was not approved by the Speaker. But I wish, if it is the feeling of honorable members that we can bring this bill. I know it's a constitutional bill which will require a referendum, but I am still willing to sponsor that bill if it is approved by the Speaker, and then we go to a referendum to remove the Senate completely. We'll remove a headache. Thank you, Mr. Speaker.
The Speaker. Just bring the bill, we shall deal with it.
Mr. Speaker, I don't have a problem. It is even in the table office. The clerk, Mr. Njoroge, knows about it, but it was not approved.
Honorable Dawood, stop name calling. Proceed.
I will bring the bill. I will ask for signatures from honorable members.
Thank you, Mr. Thank you, Mr. Speaker. Mr. Speaker, Honorable Speaker, I beg to lay the following papers on the table of the House. Today, Tuesday, 25th August 2020, table of the House. Today, Tuesday, 25th August 2026. Report of the Departmental Committee on Education. Honorable Speaker, I beg to give notice of the following motion. That taking into consideration the findings of the Departmental Committee of Education in the report on the approval hearings of nominees for the appointment of members of the Teacher Service Commission, laid on the table of the House today on Tuesday, 25th August 2026, and pursuant to the provisions of Article 252B of the Constitution, Section 8.8 of the Mrs. Antonina Lentoijoni, and 2, Honorable Wilson Sosion. I thank you, Honorable Speaker. Honorable Speaker.
What's the matter? What's out of order?
Honorable Speaker, when the order was called for chair of the Committee of Education to present papers, many of us here were sitting with anticipation of some good news that each member seated in this House now will be given 10 TSC letters to take to the constituencies. We are disappointed, very apprehensive, very disappointed that he has not done the God's work and he has left us in very bad shape. Honorable Speaker, I don't know what he has to say in respect of this matter. Thank you, Honorable Speaker.
Well, that's part of counter and banter. Next order. Yes.
Order number 8, the Creative Economy Bill, National Assembly Bill number 48 of 2026, first reading. A bill for an act of Parliament to nurture and support the development of the creative economy in Kenya by facilitating innovation, nurture, grow, and protect the creative economy sector and for connected purposes. Order number 9, the Air Passenger Service Charge Amendment Bill, National Assembly Bill number 56 of 2026, second reading.
Majority Leader.
I'll give you, but don't sell.
Majority.
Honorable Speaker, allow me, Honorable Speaker, to move that the Air Passenger Service Charge Amendment Bill, National Assembly Bill number 56 of 2026, be now read a second time. Honorable Speaker, this is a very short bill that's just about 4 clauses. And the key purpose, Honorable Speaker, of this bill is to further amend all this money was going to now obligate that the Commissioner will remit these funds directly to the respective beneficiary entities. And this will now the collector or the commissioner will be able to remit directly to the 3 entities so that KA remains with gets what is due to them, KCA gets what is due to them, and the Tourism Promotion Fund also gets what is due to them. And this will, in a way, create a lot of efficiency, not in terms of just how quickly that money goes to them, but also to allow the individual entities to then be able to progress and do what they need to do with the monies that has been collected on their behalf by KAA. The other small amendments, Honorable Speaker, are just technical ones to clean up, technical cleanups, for instance, to deal with the Senate, Honorable Speaker, because as I said earlier, in fact, we should have legislation like this that has nothing to do with this other house called the Senate. You can imagine if this, such an important bill had to go to the Senate again, and they will reject it in totality, including the title, without reading. Honorable Speaker, I am happy that this bill has nothing to do with our county governments, and therefore will not find its way to that other house, and we'll be able to expedite with this bill. A very short bill, just 4 clauses, and Honorable Speaker, I beg to move and ask members to support this particular amendment.
Honorable Bayer.
Thank you very much.
Honorable Bayer.
Thank you very much, Speaker. It's my pleasure to second the bill and beg that the air passage is usually collected by KRA. And when KRA collects this money, then it gives the money to KAA. Then KAA now gives the other beneficiaries, that is the Kenya Airports, the Kenya Civil Aviation Authority and the Tourism Promotion Fund. Honorable Speaker, this becomes a bottleneck in the distribution of these funds. And therefore, what this bill intends to do is to ensure that when the money comes from KRA, it actually goes direct to KAA, to KCAA, and the Kenya Tourism Promotion Fund.
Thank you, Mr. Speaker. One of the best practices.
Order members. I'll take that again before the Kiri.
Speaker, as I was saying, one of the basic principles of a modern business transaction is to reduce the bottlenecks in between the transitions. Mr. Speaker, elimination of delays and additional time wastage is the best thing that can be done to facilitate quick development ventures. Mr. Speaker, this is very key bill, and I second that we really need to make sure that the transactions are direct to the 3 entities, so without any delay. So, Mr. Speaker, I think this is a very basic principles of modern business practice that we need to quicken and support. I thank you, Madam.
Sir George, what's the point of order?
Yes. Using your discretion, after Honorable Udo possibly, understanding Order 95, this bill is very important but totally non-controversial. We just need to pass it so that we move on and deal with the rest of the matters. I stand under 95 so that the mover would be called upon to reply and we proceed to equally important matters like this one. Thank you.
Very well, Honorable Undo.
Thank you, Sir George. Honorable Speaker, allow me to join my colleagues in supporting the bill. The Air Passenger Service Amendment Bill 2026. And as I do so, I just want to bring the attention to the people of Kenya that ordinarily when you buy an air ticket, those who are privileged enough to fly, if you are doing a foreign trip, you pay 50, equivalent $50 US, and if you are doing a local one, 600 shillings for an internal journey. Honorable Speaker, and that amount is spread, is shared between Kenya's Airports Authority, the Kenya Civil Aviation Authority, and the charge. Honorable Speaker, probably at this particular moment, it would have been neater to set the threshold of how much KRA will charge for these services rendered. But for the purposes of expediting the process of distribution, let's support the bill. Probably if there will be any need in the committee of the whole House, we might have to set the specific amount or a percentage of how much KRA can retain for purposes of executing their duties mandated to them and the Constitution.
Bill, and I beg to reply and thank all the members who have contributed.
Honorable Member.
A bill for an act of parliament to amend the Air Passenger Service Act and for connected purposes. Order number 10, the Trust Administration Bill, National Assembly Bill number 29 of 2026, second reading.
Thank you, Honorable Speaker. I beg to move that the Trust Administration Bill, National Assembly Bill number 29 of 2026, be now read a second time. Honorable Speaker, allow me first to thank the Chair of the Jailer Committee, the Honorable Murugara, and all the members, the very many good lawyers who serve in this House and serve our country, and the Justice and Legal Affairs Committee, who have considered this bill through public participation, listened to many stakeholders. We have had a very archaic or very old realities of today's world, because this is a very old law that came into being before we had a robust financial system as we do today. Honorable Speaker, again, with the robust financial systems that exist today, we have had situations where tax avoidance, money laundering are the order of the day in today's world. Many years ago, when this law came into force, money laundering was only involved, was more rampant with people who are involved in drug trafficking or in illegal arms trade. But in today's world, Honorable Speaker, money laundering is a day-to-day affair. We got new kings called governors. And the illicit financial flows that come from our counties, Honorable Speaker, one, to provide for the creation and recognition of different forms of trusts, including charitable trusts, the non-charitable purpose trusts, and family trusts. And each of these categories in this bill has the mode from clause 8 all the way to 10, Honorable Speaker. It defines each of these categories of trusts and how they will be registered, what you need to register, the number of people that you need, either in each of these trustees that trusts that are registered, either as a charitable or non-charitable trust, other than family trust. You must have at least 3 natural persons or 1 corporate trustee. Whereas for the family trust, you shall have at least one trustee. Therefore, the clear distinction being that a family trust, you can have just one natural person, but for the charitable and non-charitable trust, you must have at least three, again, to ensure that you do not have trusts where all the natural persons who are trustees are non-Kenyans or non-Kenyan citizens. The bill requires that every trust, whether it's a family trust, whether it is a charitable or non-charitable purpose trust, at least one person must be a Kenyan citizen as provided for in this bill. The second objective, Honorable Speaker, is to provide a very clear statutory framework governing trust and to promote certainty, transparency, and accountability in the administration. Honorable Speaker, you know, trust, as I said, have been used not just for money laundering, but because of the manner in which they were being managed, many trusts, especially a few family trusts, people have been left property, and that property has ended up not benefiting the people who were intended to benefit, but benefited trustees. And therefore, this bill seeks to create that very clear statutory or legal framework that will govern how trusts are managed, what powers trustees in such trusts have, and how they can dispose of what is owned by such trusts. It also creates certainty and transparency and accountability on a non-charitable trust. Honorable Speaker, each, there is in the bill provides, without going into details, what will be required for the registration of such, each category. The bill further seeks to establish clear qualifications, appointment, removal, and resignation procedures for trustees. Again, as I said, because of the archaic nature of the law that existed, we have had trusts where people become trustees in perpetuity, Honorable Speaker, and you could not remove them. And even where beneficiaries want to remove trustees because they are not serving the intended purpose of that trust, they were unable to remove them. But this bill now seeks to create that very clear qualification on who qualifies to be appointed as a trustee, the manner of the appointment, and the manner of even their removal or resignation. The bill, Honorable Speaker, is to combat illicit financial flows. It is to combat illicit financial flows, ensuring that all domestic trust instruments cannot, under any circumstances, be maliciously subverted for money laundering or tax evasion strategies. Because, as I said again, we have seen people registering trusts either to move illicit financial flows or to facilitate the movement of illicit financial gains or financial flows, or to subvert payment of taxes. Therefore, this bill seeks to ensure that we tie all the knots to ensure that trust will no longer be used to subvert our tax laws or indeed subvert our combation or our fight against illicit financial flows. Honorable Speaker, as I said, this bill also seeks to move with the modern financial architecture in the world, because people have become very creative and very innovative. You remember, Honorable Speaker, we just enacted the Anti-Money Laundering Act last year, but
for purposes of organizing or rather by the owners of the trust. I find the bill fairly informative, especially in view of clauses 22 to 27, where the bill clearly distributing and or sharing the property of trust, and therefore basically swindling the owners of such property. The idea of defining the beneficiaries and the managing, the trust on behalf of the beneficiaries is clearly, acted upon in this particular law. Madam Speaker, when I look at the entire bill and generally looking at what has been happening in the past, I believe this bill comes in to resolve, looking at what has been happening in the past, I believe this bill comes in to resolve the many problems that have been there.
Thank you. Member for Buri.
Thank you, Mr. Speaker. I think this is a very important bill because
register. And that's the reason why we have had many people using trust as vehicles to hide ill-gotten properties so that they can run away from government. And you look at
Clause 22, it gives a proper roadmap on how one can proceed and register trust.
This has never been there before because it gives even a requirement what's supposed to contain in on the trust deed, so that you disclose the purpose of the trust, the property to be put under trust, and even the purpose, and even the beneficial owner as it is in registration of companies, so that we know that this trust was registered by so and so for this particular purpose, and these are the beneficial owners, or these are the people, the trustees, who are responsible for if there's any question to be raised. There are people to be followed legally. I therefore, having perused the act, I support that it's a very important bill that is going to provide a clear roadmap to Kenyans, so that it even makes it easier for any person wishing to register trust to move and register without any other hindrances. And also you will note, Honorable Speaker, that in this particular bill, by differentiating a family trust and non-charitable trust and charitable trust, you will note that even the churches we have are registered, some are registered as trusts. And you find that when a church is registered in Nairobi here, they have branches in Busia or Kilifi. Those subsidiary churches, they want to own property. It becomes a problem for them because they must go to the mother church to provide them with the certificate so that they can also own a piece of land, which has been very difficult. That's why we have had many people in church fighting over properties. But when you have a clear legal framework where trust can operate, it will benefit our citizens. I therefore support this particular bill.
Honorable Speaker, I stand on standing order number 96 and move that the debate be now adjourned in view of the seriousness of the matter and the need to
Member Funyula has stood on his seat, starting order number 96, that because of the importance of this matter, that instead of asking the motion to reply now, we adjourn debate. Is that the mood of the House? Yes. I therefore put the question that the debate on the Trust Administration Bill, National Assembly Bill number 29 of 2026, be now adjourned. As many of that opinion say aye. As many of that opinion say nay. Ayes have it. The debate on the bill is therefore accordingly adjourned to the next time it's laid in the other paper.
Order number 11, the Power of Mercy Bill, National Assembly Bill number 56 of 2025, second reading, resumption of debate, adjourned.
Funyula, were you on this also?
Because there's someone with the floor, so the first bite, then this afternoon goes to. There was no one on the floor, and therefore this chance goes to the member for Funyula to proceed with the debate.
Thank you, Honorable Speaker. Let me at this onset stand to support the bill, the Power of Mercy Bill 2025, national convicted, jailed, or found the wrong side of the law. Honorable Speaker, I just want to start by reading the definition of the word mercy as presented in clause 2 of the respective bill. Means compassion or forgiveness shown towards an offender by the president. Forgiveness, compassion or forgiveness shown to an offender by the president. The Constitution of Kenya contemplates, and this has been even since independence, that there could be a conviction that requires some form of mercy, excess of the power of mercy by the President of the Republic of Kenya. In the Constitution that we promulgated in 2010, it provides very elaborate procedures to ensure that this power of mercy is not abused by the person who is entitled to make those, to exercise that power. Honorable Speaker, it also provides for pardon, means grant of mercy that permits an offender who has completed their sentence. There are very many people serving in our correction facilities, serving in our prisons, who on the balance of evidence available could have been wrongly convicted, who by any chance could have been convicted because of false testimony. There has been very many cases where witnesses have come much, much later to recount their evidence that was wrongly used to convict people for no apparent reason. Honorable Speaker, as I stand here today, there was a case of mob arson sometimes in 2024 in my constituency. One of a boy who was just watching out of curiosity was found within the scene and after following the due process. Honorable Speaker, it also provides for remission, which means a grant of mercy that allows an offender to be released from imprisonment on the basis of good conduct, with the effect that all or part of the punishment is cancelled. Honorable Speaker, when you commit an offense, you are just it's not necessarily a bad person. You have been forced to make that commit an offense for various reasons. A mistake should not be a lifelong punishment, and that's why for me where I stand and sit, I don't support death penalty. Because death penalty is a finality. You have no reason for you to correct your mistakes and get rehabilitated in the society. One of the conditions can be considered. And a vulnerable offender means a female with a child under the age of 2 years or who is pregnant. Child under the age of 2 years or who is pregnant, that's a point of debate that we need to debate very carefully, because they can collude between a female prisoner and a male prisoner warder to do what they can do to make sure the prisoner gets benefits from the same. Honorable Speaker, clause 5.4 provides that the member of the advisory committee appointed on this section shall serve as part-time basis for a single term of 5 years. Honorable Speaker, now what is out of order?
Benefit from this if you are pregnant. And of course, he's a doctor. He knows pregnancy comes from conjugal rights that prisoners in Kenya do not enjoy. Therefore, just to inform the member for Funyula that prisoners in Kenya do not enjoy the rights to their conjugal rights while serving their sentences in prison. So they may not collude as he, just to allay his fears that there may be collusion between, maybe unless there is collusion between a prisoner and a sentry, the wardens at the prisons.
But where would they do that?
But they, again, is also illegal. There are no conjugal rights.
Don't represent that.
And
Where would
sexual
they-
intercourse
where
in
would
prisons
they
is
do
not
that?
allowed.
Where would they do that?
What do you mean?
This sentry and prisoner, where would they be doing this?
Honorable Speaker, you know, I have seen instances where in Kakamega Forest, the park in Kakamega Forest, they used benches. So don't asking where they would do it, Honorable Speaker. I'm just stretching my imagination. But the point is, I wanted to inform Maundo that it is illegal. Prisoners in Kenya do not have conjugal rights, unlike in some countries in the West where people enjoy conjugal rights while in prison. Here you do not enjoy, and therefore you must.
But there was a lady in between them who actually raised her hand and said, sorry, I'm expectant, so I cannot be sentenced to death. And everybody in the country was asking, how did she become expectant? So it is not a conjunction on the part of the leader majority. These things happen. They are not very common, but we are human beings. Honorable, would be happy that we are not abolishing the death sentence in the NCAJ bills that I tabled reports this later, I think early this afternoon, on amendments to the Penal Code and the Criminal Procedure Code. What we are doing is to remove the mandatory death sentence, such that the judge has a discretion to sentence you to death or give you life imprisonment, depending on the circumstances under which you committed the offense. Because judges have been complaining, mandatory death sentence is not judicial. They do not have a discretion. They must thus have that discretion. Thank you.
You are informed.
Informed, but if you went to school, there was osmosis. And Sir George knows it can also happen through osmosis, Honorable Speaker. In any case, I'm very well guided and informed. Honorable Speaker, Article Clause 12 of the bill, Provac has a very curious provision that we might have to read the report of JLAC to understand how to treat it. It provides that despite Section 1, Subsection 1, in the performance of its duty, it means then we'll continue with the same systematic mistake and we might end up in the same problem. Honorable Speaker, probably might have to question the wisdom of a full-fledged secretariat, considering that this advisory committee will be domiciled in the office of the president. We might have to ask the necessity of a full-fledged secretariat, yet there's some work that can be done. And in addition, Honorable Speaker, we have the Power of Mercy Case Management Committee in each correctional facility. We might just have duplication of roles that are basically not necessary, Honorable Speaker. Of course, Honorable Speaker, I want to be very clear, and I'll need this further, because when you go to Clause 28, the bill makes a reference to positions in the public service that are not provided for in the Constitution. For example, they say, Honorable Speaker, in Clause 28, one of the bodies to be consulted is the Directorate of Criminal Investigation. Honorable Speaker, when you go to Article 239 of the Constitution of Kenya, the security organs is Kenya Defense Forces, National Intelligence Services, and National Police Services. Of course, everybody will ask, where does the Criminal Investigation Agency come in a matter that surely looks more like a constitutional provision, not a matter of legislation? Honorable Speaker, in the same Clause 28(5), ELAC is to remove any chance as a sexual offender and a serial sexual offender can be given, can benefit from the prerogative of the president on the mercy, on that. Also, again, Honorable Speaker, violent offenders who cause serious bodily harm to the victim where the offense was found to be motivated by discrimination, including gender-based discrimination, gender-based violence, female genital mutilation, domestic violence, ethnic-based violence, or violence against persons with disability. Honorable Speaker, on that I will have to move an amendment because that's abuse of the prerogative of power of mercy by the President. Honorable Speaker, as I conclude, Honorable Speaker, if you walk to many of these prisons, and I'll start with the prison in Busia, Korinda, I can bet there are people who are wasting space in prisons for very petty offenses. If you are arrested in taking Samia gin or Nguri, that cannot be an offense warranting you to go and rot in prison. That's an offense they can just make you stand, you sober up, and continue the activities. Honorable Speaker, there are some things that don't, then there is also, you would find the policeman, will find you walking in the evening late at night, they arrest you for loitering with the intent to commit an offense. Because they cannot prove that offense, they can't plant on you some basic things like bank as the office of the prosecutor or the DPP. Let's look at the offenses that can take somebody to prison. There's a provision in the law for community work. It would be much, much, much easier and more effective and beneficial to the community if those arrested for pet offenses going to go there, get them out. It does not make economic sense. Let's have effective use of our resources. When Uncle Moody was the Minister for Interior, Uncle Moody, he's the one who brought beds in prisons. So majority leader, the beds there can be used.
The Honorable Murugara. Murugara. The Honorable Murugara, it turns out that you already contributed on this bill. No, you did already, so. He's not on the floor anymore, and you know that you can only inform him if he's on his feet. I gave you already. The Honorable Order. The Honorable Murugara. After the Honorable Leader informing the Honorable Undo, I gave a chance to inform him, didn't I? And said, yes, so let's leave it at that. The Honorable Mutunga, do you want to contribute to this? You did. So, the Honorable Bayer, go ahead.
Thank you, Honorable Speaker. I support this bill. I think this is a very progressive piece of legislation, Honorable Speaker, that tries to amend the Power of Mercy Bill 2025. Honorable Speaker, I think it is very important that we give effect to articles of our Constitution. And this is one such bill, that Article 133 of the Constitution provides for the appointment, tenure of office of the members of the Advisory Committee on Power of Mercy and the powers and functions of the Advisory Committee on the Power of Mercy for connected purposes. I think this is a very progressive piece of legislation. The Power of Mercy office, there is a department called the Power of Mercy. If you go to the building, the National Library, I think it's at the National Library, you go there, you will actually find a good beginning. And I think it is important, like my friend Dr. Oundo has said, it is very important that sometimes offenders get into, or prisoners are imprisoned sometimes not because of offenses that they committed, but just because by law or by operation of law or by some misjudgment somewhere, they end up in prison. And sometimes these prisoners actually they're actually not criminals, but they are there, and they should get a leeway in which they can get out. Sometimes prison sentences are imposed that as long-term prison sentences, but as a person stays in prison, power of mercy to be exercised by the president alone. But this law provides a mechanism in which to arrive at the decision at the end where power of mercy is exercised. And I think that's an important thing, because the president cannot just come to a prison and say, you and you and you and you are pardoned, go out. He cannot do that. There has to be a mechanism, a foolproof mechanism to say, this one can be pardoned. This one can benefit from power of mercy. This one can benefit from power of mercy. And that's why this bill is important. Secondly, Honorable Speaker, it is also important to note which offenses cannot benefit from power of mercy. I've read Section 28, for which my brother, Dr. Undo, talked about. But there is this Section 28. The President may, pursuant to Article 133(1)(b) of the Constitution, on the advice of the Advisory Committee, grant a conditional pardon, custodial sentence in case of an offender serving an indeterminate sentence, or 1/3 in case of an offender serving determinate sentence. And then it comes to the areas where my brother Oundo was talking about in five. And I think these are important things, Honorable Speaker. Despite Section 3, sexual offender is most likely to repeat that offense when he is released. And again, enjoy justice when the offender has been offended. You say, finally I got justice. When somebody kills another person and that person is jailed, the family will say, finally we've got justice. Then 1 year, 3 years down the line, the person comes out to walk scot-free because he has been pardoned. How restitution, justice, is also part of restitution, Honorable Speaker. And therefore, it is very important that these offenses be removed from the list of those who can benefit from the prerogative of mercy of the President. That I agree. And on a petition being made pursuant to Section 26, substitute a less severe form of punishment on medical grounds. Honorable Speaker, there are people out there in our prisons who, even that imprisonment does not serve the purpose for it, because they are terminally ill. They are on medical grounds. They suffer from an incurable terminal illness or a highly contagious disease. The prerogative of power of mercy can be exercised, Honorable Speaker. If a person is entirely incapacitated, requiring assistance with the activities of daily living, that person can enjoy the prerogative of power of mercy. If a person is of advanced age, that person should enjoy power. Is critically ill or is pregnant. The Honorable Leader said this is debatable. How does someone become pregnant in prison? Until the one that Honorable Mayaka is talking about. Honorable Speaker, these are enough grounds. A person is pregnant and is in prison, is a lactating mother or the sole caretaker of a dependent child. Honorable Speaker, I think power of mercy could be exercised in this. Honorable Speaker, it is very important to say, if you have read the book by Dr. Sosky, the one called Crime and Punishment, crime must be punished. Crime must be punished. Crime against a citizen must be punished. Crime against the state must be punished. But even when we do that, we must do it in such a way that it is not a complete sentence out of life, out of society, and that is why the framers of our Constitution introduced Article 133, that we can actually exercise 13th Parliament this law that must guide those structures, those people who have been given the authority to help the head of state to exercise power of mercy. And therefore, with all those things that I have said, Honorable Speaker, I am convinced that this is a good law. It is actually an expression of constitutional articles, and that we are giving effect to that constitutional. And I think this 13th Parliament should go into history as one that gave a lot of effect to many constitutional articles. Honorable Speaker, I support.
Okay, Honorable Bishop Kosgei.
Of Article 133 in our Constitution is necessary to be given legislative attention in order to facilitate the constitutional right provided for through the the hand of the president or the leader of the country. Mr. Speaker, it has been said there are people in jail today who are supposed to be outside, and there are those roaming around who are supposed to be in. Give such people a second time. So, Mr. Speaker, this bill has come at an opportune time. The second reason that has come out is that, you know, our prisons are so congested and people are increasing with many petty crimes around. And I think this particular, if a clear sign of reformation has been given or has been witnessed, then they deserve to have the mercy of the president. Finally, Mr. Speaker, it is observed that while exercising this, there are some new development that they will never learn a lesson anyway. So there could be some other alternative ways of helping the same. So with that, Mr. Speaker, I support the bill.
The Honorable Jalas, do you want to speak on this? The Honorable Jalas, do you want to speak on this? The Honorable Felix Odiwuor, because I can see you're keen to speak.
For giving me the opportunity to also add my voice to this bill. Mr. Speaker, at onset, I support the bill. I note that the bill provides a clear legal framework governing the exercise of power of mercy in Kenya, focusing on pardons, commutations, remission of sentences, and related presidential prerogatives, while at the same time enhancing transparency, consistency, and accountability. Mr. Speaker, the key provisions I've noted to be merit and criteria for consideration. It establishes the principle guiding mercy decisions such as length of sentence reserved, behavior, humanitarian grounds, and impact of the victim. Mr. Three, the other provision is on the Independent Advisory Committee, which is a good thing, which creates a power of mercy committee, and it will receive and screen petitions. It will make recommendations to the president, ensure consistent application and fairness in the exercise of mercy powers. Two, it will also ensure consistent standards in the decision making and enhance accountability to the public and also to us, to Parliament. And it will give a victim a structured voice in mercy processes. Mr. Speaker, it also encourages rehabilitation and humane treatment of offenders. Mr. Speaker, however, I've noted that there could be, not necessarily that there are challenges, but there could be challenges, Mr. Speaker. One, that it requires adequate resourcing for the advisory committee and administrative functions. Mr. Speaker, another possible challenge is that victim participation could complicate or lengthen the process. The third one is striking or finding the right balance between mercy and public safety may be at times complex. And finally, implementation depends on political will and procedural discipline. And we've seen this in several other issues, similar issues. Mr. Speaker, with those, I know that you are concluding on this debate. I wish to state again that I support. Thank you.
Honourable Speaker.
Go ahead.
Thank you very much, Honourable Speaker. Honourable Speaker, listening to the members and the debate on this particular bill, Honorable Speaker, we are not differing in anything. We are actually paraphrasing now. I will propose
Order.
that
The Honorable
Speaker,
the Honorable Order. The Honorable Mutunga, take your seat. Just take your seat. Order. Take your seat. The Honorable Murugara, could you proceed to reply?
Thank you. Thank you very much, Honorable Speaker. Honorable Speaker, I wish to thank each and every member who has made a contribution to this. This is a very important piece of legislation. And it has a long checkered history, right from the road in England all the way up to where we are today, exercising first and foremost, it was called the presidential prerogative. Now it is the power of mercy. Be corrected so that you come out a reformed person. So, when you exercise this power of mercy, it is going to extend to all offenses, but with certain conditions, including murderers now. And it may not be fair to call them murderers, though once they are convicted of murder, they become murderers. Once you are convicted of murder and you are sentenced to a prison term, say 10 years, for reasons we are setting out in the bill, you'll be actually eligible to apply for remission or for the power of mercy to be in your favor. We have also talked about sexual offenses. And here we have to make it very clear, not all sexual offenses to ladies, men and ladies, including what is called indecent assault. We have some other offenses which are not clear to all of us, like indecent exposure. All these are sexual offenses. Some of them are lesser, and therefore you'll be entitled to apply. Those are a raft. If you have keen interest in this, look at the report by Justice and Legal Affairs.
Honourable members, after that, look and reply, therefore put the question that the
A bill for an act of parliament to make further provisions with respect to the power of mercy pursuant to Article 133 of the Constitution to provide for the appointment, tenure, powers, and...
Member for Nambale, on behalf of the Chairperson, Department Committee on Energy, you're on your foot,
Raise the following serious concerns. Number one, costs without a financing plan. The policy will cost an estimated Kenya shilling 68.29 billion to implement. However, it carries no finance strategy, no funding commitments, and no way of ranking priorities. The committee recommends, which has never been implemented. Section 119 of the Petroleum Act 2019 is the implementation matrix even treats public participation as optional. The committee recommends that the framework be operationalized and that the Cabinet Secretary submits a position paper on Kenya's access to the initiative. Number three, the Petroleum Revenues and Sovereign Wealth Fund. The policy provisions on revenue management are not developed enough to support stabilization of revenues or wealth for the future generation, and they make no reference to the Sovereign Wealth Fund Bill 2026, which was read the first time in this House on 11th March 2026 and is now an act of parliament. That act proposes a fund with a stabilization component, an infrastructure and development component, and a future generation component. The committee recommends that the policy be aligned with the bill once enacted, and this is important. Mr. Speaker, that petroleum revenue going into the fund be first paid into consolidated fund and appropriated by this House in accordance with the Article 206 of the Constitution. Number four, provision of the policy that is contrary to the law. The committee found that the policy places custody of upstream petroleum data with the ministry. Section 10D of the Energy Act 2019 expressly assigns that function to the Energy and Petroleum Regulatory Authority. The policy is therefore inconsistent with the statute. The committee recommends that the policy be revised within 6 months to vest petroleum data custody and oversight in the authority and confirm the separation of policy, regulatory and commercial function between the ministry and the authority and the National Oil Corporation. Number 5, local content and lessons from the Turkana. The local content provisions are broad with no measurable targets, no timelines, and no enforcement. The committee was reminded of the early oil pilot scheme in Turkana, where local employment was limited, capacity building was lacking, and local business barely featured in the supply chain. Without firm local content rules, this sector risks becoming an enclave industry. The committee recommends a robust local content framework with clear targets, monitoring, and capacity building. Number 6, community land consent. Where community land has been registered under the Community Land Act 2016, communities now hold contaminated hazardous waste liners and of poor disposal and decommissioning in Lamu. The National Oil Spill Contingency Plan remains largely unimplemented. The policy also omits environmental deposit bonds, even though regulations for them already exist under the EMA and EMA. NEMA is missing from the decommissioning process in the implementation matrix. The committee recommends binding safeguards on hazardous waste, oil spills, preparedness, decommissioning, and restoration, and that NEMA be expressly designated the principal environmental regulator at every stage of the petroleum operation. Number 8, consumer and security of supply. Honorable Speaker, because we import almost all our fuel, global price shocks are felt directly by the Mwananchi. The policy does not provide an adequate emphasis on engineering standards and professional certification. The committee recommends that this be mainstreamed and that a national petroleum data repository with data over sovereignty protections be developed. Honorable Speaker, having considered all the submissions and observations, the committee recommends as follows. Number 1, the House adopt this report on sessional paper number 4 of 2026 on the National Petroleum Policy. Number 2, that following the adoption of the policy, all proposed legislation on oil and gas matters be guided by the policy. And lastly, that the Cabinet Secretary for Energy and Petroleum, the Energy Petroleum Regulatory Authority, the National Environmental Management Authority, and other relevant state agencies implement the directives set out in the report, and that the Cabinet Secretary reports to the committee on the progress made within 12 months of the adoption of this report.
The Honorable Victor Koech.
Yeah, thank you so much, Honorable Speaker. As I rise, I would like to, the Speaker of this House then had put to the committee, and we did a proper public participation that was both quantitative and qualitative.
And the member on his feet now. I will allow you to do what you're doing. And the member on his feet now. I will allow you to do what you're doing now, but next time I won't allow you to read your submissions word for word. You will proceed that way today, but in future don't do that. Proceed.
Thank you. Well guided, Honorable Speaker. Like I was saying, without repeating myself, I would like to put across to the floor of the House on the observation that we made and anything else that have been said out by the move of the motion, and that's cut across everything else. That includes the completeness of the institution charged with the implementation of this policy. Honorable Speaker, it is a awakening call to this particular House that recently this House passed an FDP, that is the Field Development Plan. And equally, Honorable Speaker, moving the production of oil from Logichar all the way to the coastal region, Honorable Speaker. And some of those then that integrates everything else that have been left out. With those very few remarks, without repeating myself, Honorable Speaker, allow me then to second. I beg to second. Thank you.
Well said. Members, the motion having been moved ably and seconded ably, I now propose the motion that this House adopts the report of the Departmental Committee on Energy on its consideration of the National Paper number 4 of 2026 on the National Petroleum Policy, laid on the table of the House on Thursday, the 2nd of July 2026, and approves the National Paper number 4 2026 on the National Petroleum Policy. The Honorable Mawadi, you want to contribute to this?
Thank you, Mr. Speaker. I rise in support of this motion and make a few comments. There is need for us to really consider the local content of any of the local Kenyan. Also, there is need to strengthen a knock. Most countries have national oil companies.
Would I therefore then call the mover to reply?
Thank you, Honorable Speaker. Honorable Speaker, I wish to thank the Honorable Member for Embakasi South and also a member of the Energy Committee to have made a contribution on this bill. Honorable Member, the House will note that this is the first standalone policy on petroleum this country has ever had since the year 2004, and I therefore urge the members to consider the key concern, the 9 key concerns that the committee raised while going. The 9 key concerns that the committee raised while going preparing for this particular policy, so that
question that this House adopts the report of the Departmental Committee on Energy on its consideration of the National Paper number 4 of 2026.
Order number 13, motion, appointment of an external.
Very much, Mr. Speaker. Mr. Speaker, I rise to move the motion that the House approves the appointment of MS MGI Alekim pursuant to Article 2264 of the Constitution. Mr. Speaker, before I discuss the contents of the report in summary, yes.
I would like you to move this motion the way it is in the order paper. Then you proceed with what you want to say next.
I have to read first. Sorry, Mr. Speaker, I was using the summary in the report. Yes, that's for my, I agree. It's for my. I'll repeat for the record, Mr. Speaker. Thank you very much. Mr. Speaker, I rise to move the motion that this House adopts the report of the Public Accounts Committee on procurement of external audit services for the Office of the Auditor General for the financial years 2025, 2026, 2026, 2027, and 2027, 2028, laid on the table of the House on Thursday, 13th August 2026, and pursuant to the provisions of Article 2264 of the Constitution and Section 43 of the Public Audit Act Cap 412B, appoints MS MGI Alekim LLP for purposes of auditing and reporting on the accounts of the Office of the Auditor General with respect to Roman 1, accounts of the Office of the Auditor General for the period 2025, 2026, 2026, 2027, and 2027, 2028, and Roman 2, the financial statements for the staff mortgage and car loan scheme for the Office of the Auditor General for the financial years 2025, 2026, that has made this report to come before this House, Mr. Speaker. Mr. Speaker, the constitutional mandate and legal framework is derived from Article 226, Auditor General. Mr. Speaker, it goes further to state 2264 states clearly, Mr. Speaker, that accounts of the Office of the Auditor General shall be audited and reported on by a professional qualified accountant appointed by the National Assembly. Mr. Speaker, I want the House to note that it is this provision of the House appointing the auditor. We need to get credible and trust of the supreme body. Mr. Speaker, when you talk about credibility and trust of the supreme body, we are talking of the objectivity, the accuracy, and free from bias. Mr. Speaker, we also need to enhance transparency because this body audits other government entities, and therefore when it's audited, Mr. Speaker, there is the case of enhancing transparency. Mr. Speaker, we also need to improve performance. And Mr. Speaker, assessment helps identify operational gaps and adopt global best practices for this supreme body. Mr. Speaker, going further, you'll find that the moment we audit the supreme body, the Office of the Auditor General, we shall ensure compliance, Mr. Speaker. Mr. Speaker, which talks of fairness and unbiasedness, Mr. Speaker. We have the fair presentation. We have the due professional care, confidentiality, independence, and evidence-based approach, Mr. Speaker. Therefore, Mr. Speaker, when I go back to the report, which has been presented to this House by our committee, the Public Accounts Committee, Mr. Speaker, you'll find that to fulfill the constitutional obligation, the National Assembly initiated an open competitive procurement process through a request for proposal for the provision of external audit services for the Office of the Auditor General. Mr. Speaker, the tender was publicly advertised on the 11th of March, 2026, on the National Assembly website and the Public Procurement Information Portal. Mr. Speaker, following a pre-bid meeting, 6 firms submitted their bids by the closing date of 24th of March, 2026 at 11 a.m. Mr. Speaker, the first firm was MSSKM Africa LLP.
It's read as Messrs, not MS.
Messrs.
Messrs, like
Messrs.
Misters,
SK.
plural, yes.
Okay. Messrs. SKM Africa LLP, Messrs. MGI Alekim LLP, Messrs. Ndakala Advisory LLP, Messrs. Baka Tili, and Messrs. RSM East Africa Limited Liability Partnership. Mr. Speaker, the evaluation and findings. The evaluation committee appointed by the accounting officer pursuant to Public Procurement and Asset Disposal Act, Cap 412C, subjected the submissions to a vigorous 4-stage evaluation process. Mr. Speaker, preliminary stroke mandatory evaluation were 5 firms of the 6 bids were disqualified for various non-responsiveness issues, and as uncommissioned powers of attorney, missing registration certificates, missing security bid, and unverified professional indemnity covers. So, Mr. Speaker, you'll find that during the evaluation process, we have the mandatory requirements which every company has to qualify. And from the report, the evaluation report, it shows that 5 out of the 6 firms failed to comply with the mandatory requirements. And therefore, only 1 firm, which is Messrs. MGI Alekim LLP, was the only firm that met all preliminary and mandatory requirements, therefore proceeded to the technical stage of evaluation. Mr. Speaker, making reference to page 1 of the report, for members who have the report, I'm making reference to page 1, which has listed the companies and the outcome, Mr. Speaker. Mr. Speaker, going forward, the technical evaluation, in bracket, quality and cost-based selection, Messiah's MJI Alekim LLP attained an average technical score of 79.7%, surpassing the 75% pass mark. Mr. Speaker, will note that the Public and Procurement Act stipulates that during technical evaluation, a company should surpass 75% of the score. And Messiah's MGI Alekim LLP attained an average technical score of 79.7%, surpassing that mark. Financial evaluation, it's a financial bid of Kenya shillings 6,497,400, inclusive of all applicable taxes and levies. This financial bid was opened on 21st of May 2026. Mr. Speaker, applying the weighted combined scoring criteria, 80% technical and 20% financial, Messiah's MJI Alekim LLP attained a final combined weighted score of 83.8% points, ranking highest. In line with the above, and through professional opinion number NA/June 2026, and on appeals, and no appeals were lodged within the prescribed period. So, Mr. Speaker, you'll find that once the company that has scored the highest is notified through the intent to award, the Procurement Act gives 2 weeks for any company that participated and had got grievances to file an appeal. And it's clear, Mr. Speaker, that the 5 other firms did not file an appeal against the award. Committee observations and findings, Mr. Speaker. Honorable Speaker, at its sitting held on Thursday, 6th of August 2026, Mr. Speaker, its financial statements, staff car, in terms of the value of the tender, Mr. Speaker. Mr. Speaker, on page 4 of the report, that these services are going to be offered for 3 financial years. This cost is not that high compared to the previous costs that we have approved in this House. And Mr. Speaker, you'll find that many firms, the reason why the response to the tender was low is because many firms, Mr. Speaker, fear or get to a disadvantaged stage where they are told to audit the Auditor General. Because the nature of auditing, Mr. Speaker, is that where the Auditor General feels like he can't or she can't do the responsibilities to satisfaction, she can hire an outside firm to help. And therefore, the moment that you'll also find out that during evaluation, especially on technical, Mr. Speaker, the criteria or the score is normally very high because you are going to audit the firm that audits all government entities. All government entities, I mean the national government and the 47 county governments, Mr. Speaker. And therefore, the technical score or the technical qualification is always very high, and that's why many companies might not be in a position to attain those high scores, Mr. Speaker. And therefore, Mr. Speaker, the committee did its observations, and we have given our recommendations. And therefore, Mr. Speaker, I recommend that with those few remarks that this firm, you said it's messiahs.
Messers.
Yeah. So Messrs. MGI, Alekim LLP, Mr. Speaker, be given the go-ahead. My colleague, the Member of Parliament for Mathioya, a committee member of Public Accounts Committee, to second, Mr. Speaker. Thank you very much.
But that is a very elaborate, exposition of your motion, the Honorable Tindi. I'm sure even anybody listening from out there understands what you are trying to do in the House this evening. The Honorable Member from Mathioya, Doctor, I'm told you got 3 PhDs. Go ahead.
Yeah, thank you very much, Mr. Speaker. And I would want to second the motion by my able chairman of the Public Accounts Committee, Honorable Tindi Mwale. And Chair, Mr. Speaker, just as you have said that the report was elaborate, I might not have much to say. But given the task that this company, 2728, and they will be auditing the financial statements, the staff, car, and mortgage schemes, all those costs, all those activities at a cost of around 2.2 million Kenya shillings per financial year. I think it's a very moderate and fair cost for such an activity and for such a task. And for those few remarks, Honorable Speaker, I beg to second. Thank you very much, Speaker.
Thank you. All members, the motion having been moved, ably and seconded, I therefore propose that this House, 26, 2025, 2026, 2026, 2027, and 2027, 2028, and 2, the financial statements of the staff, mortgage, and the Honorable Majority Leader, you want to contribute to this?
Thank you, Honorable Speaker. I would like to contribute to this report and support it. And on the offset, thank the Honorable Tindi Mwale for a good job well done. Honorable Speaker, appointing an auditor for the government, the auditor to audit the auditor, is a Herculean task. It's not easy because you must bring in experience, you might bring in high level of understanding, and you must also bring in somebody who has high levels of integrity, because this is an auditor of the auditor. And I think I am very, very glad and happy that now we have somebody that we are tabling in this House
for the appointment in the name of Mrs. MGI Alekim LLP as that firm that is going to audit the Auditor General. Honorable Speaker, the tenets of audit are actually mainly to bring in transparency, accountability, and good use of public resources, Honorable Speaker. And these are some of the tenets that Parliament stands for, because these are public funds. They're money for the people. There can't be government without taxes, but also there cannot be taxes taxes when they are taken, they must be accounted for properly. Now, the Office of the Auditor General also receives funds. I am not aware how much money the Office of the Auditor General has spent so far, and especially for the financial years that you have put in here. I'm not so sure how much, but I want to imagine that the books of this Parliament bear me witness that it is colossal. It is a lot of money. And I remember in the 12th Parliament, there was this debate on whether the Auditor General's office must get a lot of money, more money, for it to do a good job. And we did that during the Auditor General called Mr. Ouko. We actually allocated more money to ensure that there's effectiveness in the Office of the Auditor General. Because the Office of the Auditor General receives funds from this House, it is important that we appoint an auditor to audit the accounts of the auditor, to see the audited reports of the Auditor General's office being tabled in this House, so that we can look at them, scrutinize them, and see whether the Auditor General actually to audit the accounts and report to the House the accounts of the Office of the Auditor General. With respect to the accounts of the, I want to call upon members of this House to support Tindi Mwale's team and his report for the good job. I am sure they have put in all levels of acid tests, all manner of tests, to ensure that we pick one person, one firm that can actually pass the test of time so that they can audit the Auditor General. With those many remarks, Honorable Speaker, I beg to support.
The Auditor General is a very interesting issue to us and to every Kenyan, so that at least we know whether they are living by the practice, they are leading by example. Honorable Speaker, I've taken for having made the decision to apply for this job and knowing the risks that they are taking, so that at least the Office of the Auditor General, how they manage their resources. Honorable Speaker, I'm sure it's a firm that is
destined to grow very fast because many Kenyans will have confidence in them, and therefore they are likely to even expand their network, because their network is considered to be worldwide. It's a top global ranking accounting firm, and I'm sure it's going to be more integrated in this country. It will grow like the ones we know that are in this country that have come, our headquarters, or they are based in, they started in other countries like Ernst & Young and many others which have been auditing in this particular country. Honorable Speaker, auditing the Auditor General is like examining the doctor, and it is interesting for us.
I thank you, Mr. Speaker. Indeed, the presentation by the chair of this great committee is showing us a lot of confidence in the performance of the committee. I therefore congratulate the committee for doing a good job in excessive, particularly where they are not checked. So when we have an auditor to audit the Auditor General, this is a very powerful office in this country. The Auditor General can bring down the government if not really taken care of. There was some questions a few months back, how the Auditor General misuses funds. It was in the public, how do they themselves use their money that is allocated to them? You know, since they audit others, they were not being audited or how the money allocated to them, meaning they were not properly checked. Therefore, when we have a credible auditors to audit our Auditor General, it must be above board. This must be an international accredited and known firm. Mr. Speaker, one of the greatest problems that we are having in this country is the issue of credibility. The resources that we are utilizing is the public money. Various institutions of the government, they use taxes that are being paid. And therefore, how this money is being used by the respective enterprises is of what we can see and appreciate as of compliance. We need to know whether the Auditor General complies with the international standards of audits and financial systems, Mr. Speaker. We need to know whether the Auditor General is in compliance with the law of the land. We cannot know that unless it is brought out by another auditor to tell Kenyans that this Auditor General is in compliance with the international, because we are international village. Mr. Speaker, how independent is our Auditor General? I think that's a very serious question that we need to ask. Some of them are saying the Auditor General of Kenya is controlled by, I don't know, so what is so. The other saying it's controlled by the government. Others are saying it's being used by opposition. Others answer report of our Auditor General. And finally, Mr. Speaker, I would like to state as follows. One, we sometimes deal with audit report going back as 10 years or even 15 years. So we really need to know how the Auditor General, what is this that is causing them to delay in producing their reports? Because we must have some standard benchmarks. Because if really we are dealing with the report of 10 years ago, I think we are not really moving with the current. Therefore, in order to improve the performance, they must be taught where their weaknesses are, where their recommendations are, where their strengths are, and what they need to do, Mr. Speaker. Again, as I said, the element of misuse of public funds is a critical issue. And therefore, really, we need to have somebody very keen on the way our money is being used. With those few remarks, Mr. Speaker, I support this.
What is it? You want to contribute?
Wa mkaguzi mkuu wa hesabu, kwa sababu yeye anatumia fedha za umma. Kwa hivyo itakuwa ni uzito sana, yeye anakagua lakini yeye hakaguliwi. Yoyote yule ambaye anashika fedha za umma lazima azihesabu, azieleze matumizi yalikwenda namna gani na hesabu imefikia wapi. Kwa hivyo mimi nisimama kuunga mkono kamati kwamba wamefanya kazi nzuri, wana mawazo mazuri, kwamba yoyote anayedhibiti pesa za umma lazima akaguliwe, kwa sababu yeye alikuwa anakagua lakini hakaguliwi. Kwa hivyo ni vyema sasa hata huyu anayemkagua yeye, ikiwa atapewa pesa pia yeye atakaguliwa, kila mtu aseme vile pesa za umma zimeenda vipi. Asante sana Mheshimiwa Speaker.
Asante sana, umenena vema, lakini
powers of the Office of the Auditor General, Mr. Speaker. 2264 stipulates clearly that we need to appoint an accountant who shall audit the accounts of the Office of the Auditor General, Mr. Speaker. And therefore, Mr. Speaker, for us to enhance credibility in auditing of this great Republic, Kenya, Mr. Speaker, for us to enhance transparency, it is prudent that the Office of the Auditor General is also audited, because this house allocates resources through the process of budgeting. We allocate resources to the Office of the Auditor General. These resources is taxpayers' money, and the Office of the Auditor General uses these resources to audit public entities, both at the national government and the county government, Mr. Speaker. And therefore, Mr. Speaker, it's prudent that we do a follow-up to know if the auditor is using the funds prudently, or if the Office of the Auditor General is as the office